Hi, and welcome to Dollars and Making Sense, a weekly show about finance, money, and investing. I'm your host, Ray Treverson from OTG Capital. We broadcast locally at Radio Northern Beaches and around Australia on the Community Radio Network. We also go out on Spotify, YouTube, iHeart, of other multi-year wonderful extravaganzas. And I'm really, really pleased to welcome back to the microphone Ian McLeod, who was on our show just recently, and he's from RP Emery Legal Documents. And Ian was talking to us about when the poop hits the fan and you need to get some financial agreements together and you're splitting with your loved one. Again, Ian, welcome to the show. But look, it was one of those shows that you sit there and scratch your head and hope that people don't have to get, but the fact of life is they do, don't they?
Yes, unfortunately, the reality is that I think the figure is 40% of first-time marriages end in divorce within 10 years.
Okay, so it's a 50% hit rate. So obviously that 40% remarries and keeps busting up. So there you go. and again, in the interests of transparency, I've been married for over 35 years. A lot of this stuff, I couldn't even contemplate it. The fact that my wife would just kill me, but no, not at all. We just, I think I got lucky. I'm certainly punching above my weight in that regard. But look, what we're going to talk about today, ladies and gentlemen, is probably one of my favorite movies. Is the backdrop. It's a Coen Brothers movie called Intolerable Cruelty. It stars George Clooney and Catherine Zeta-Jones. It's incredibly funny, but it's about divorce, and rather than divorce, which we talked about the last show, it talks a lot about prenuptial agreements. Now, here in Australia, a prenuptial agreement, Ian, is a well-known term, but you have a different set of terms for that, don't you?
Yeah, that's right. In Australia, a prenuptial agreement, its proper name is a binding financial agreement. So
that doesn't sound anywhere near as glitzy as prenuptial, does it?
No, it doesn't. Yeah, but you can make a binding financial agreement before a marriage, or before a de facto relationship, or during a de facto relationship, or during a marriage.
Isn't that interesting? I guess one of the funny things, and because I have a lady called Philippa Hunt who runs a website called Wise Girls Academy, and she talks a lot about educating women. And I guess of that age, she's like us, a little bit older than the median average, we'll say. And so from that perspective, she deals with a lot of women that are having relationship breakups and the financial stress from that. And I guess I'm really curious because when I first met my fiancée, now wife, the idea of talking about a prenuptial agreement, I think, was the last thing on our minds. I guess the biggest question I've got is, how common is it?
Oh, look, it's well, I see it every day. I can't give you a statistic for the wider public, but certainly when it comes to parties who've already been through the mill, so they've been through one relationship, all right, and they it might have been a messy relationship or whatever, and they come out and they might have a home left. Let's say, seeing you're talking about the women, I'll just give you an example. Okay, so quite often we'll have a lady who's come out of the marriage. She's got a house, she's got a couple of kids, she might have a little bit of superannuation, all right, and she's still got a job, all right, but that's all she's got. And it's incredibly important to her that she protect that in the event if she starts another relationship. What happens then? What happens if she starts another relationship with a partner, and if that relationship fell over, is she going to have to divvy up her house and her super and what she's got left? So some women are very reluctant to even start a relationship because of fear of losing what they may have. And so in situations like that, a binding financial agreement can set out, look, in the event if this relationship fails, if it doesn't, if we don't live happily ever after, but let's hope we do, all right, then this is how we want our stuff to be divided, all right? I want to keep my house, I want to keep my superannuation, I want to keep the property that I have now. We'll call that separate property. And the other party may quite often has been through exactly the same thing. And a financial agreement is one way of saying, look, we're going to progress with this relationship on the grounds of, in the event if it doesn't work out, you get to keep your stuff, I get to keep my stuff, and if we buy stuff together, we're going to share that.
Is that the most common outcome that you've seen in your experience, Ian?
Yeah, like most of these arrangements are very much the same. You know, somebody has something that they want to protect, right? And it might be that one party has a lot more than the other that they want to protect, and the only way around protecting your property and continuing on with a relationship for some people is to put a binding financial agreement in place first. Lay out some ground rules.
It's a funny thing, and we mentioned in the previous show, I did my uni course many, many years ago, but I had the pleasure when I went to do my master's degree, my legal unit was done by a gentleman called Bob Vermeesh, who wrote the book on business contract law in Australia. And so we went into a lot about terms and conditions and the length of agreements, etc. And having come from the software industry as well, these things that you sign when you sign software, for example, when you sign a software agreement, they're called EULAs, end user license agreements.
Yes.
The thing that most people don't understand is that they're so long and unwieldy that they are in effect unenforceable. And so my question to you after that long-winded intro is, even after you've gone through and done this binding financial agreement, is there a way that it still can be circumvented in the longer run?
Yeah, there are provisions built into the Family Law Act that enable a financial agreement to be set aside by the courts. So if you have coercion, dishonesty, one party has tried to mislead the other when they've put this agreement in place, then the courts can step in and set the agreement aside, right? So they're not absolutely bulletproof. However, you can make them as strong as they can possibly be simply by being honest with your partner, by disclosing.
But that assumes malfeasance, I guess. If a court's going to set aside an agreement because of, let's say, it's duress or you're not fully informed. But I'm trying to think of an instance where it's been fully disclosed, it's fully transparent, but the complexity is such, or simply the length of time that they've been together, the court may decide, look, you guys have been remarried for 20 odd years, or you've been married for 20 years. Let's say they did the prenup as a first timers. Have you seen in your experience that where the court may set aside the provisions of that prenuptial and say, you know what, we've got special circumstances? Is that still possible?
Look, when in our agreements, we have the option to put into that document a set term. All right, so the agreement would
come like a
come to
time
an end.
clause.
Yeah, so it's a what we call a sunset clause.
Of
So
course,
the agreement may come to an end in 5 years, 7 years. At the top end, we say 10 years. Like us, when we're young, we're relatively strong, all right? But as we get older, we get weaker. So if you think of an agreement that's put in place today is going to be strong and it's going to protect the parties, and it's so long as you've done the right thing, you haven't tried to mislead each other or been dishonest in any way, that agreement will be strong. But over time it'll become weaker because we don't know what's going to happen with the Family Law Act. The law could change. We don't know what's going to happen with case law because there's these types of agreements are coming before the courts on a regular basis.
Really?
Sometimes they'll be set aside, sometimes they won't. Sometimes they'll be upheld. But we don't know what the case law is going to say in the future. We can prepare for the case law that's already come before, but what comes next? Who knows? Nobody has a crystal ball. So the thinking is that if you include a sunset clause in the agreement and you're forced to come back to that agreement in 5, 7, 10 years time, then the new agreement will be stronger. So you're just looking much like you do with a will. You revise your will each few years because you want it to keep pace with your life and your children. Much the same, lawyers will advise you to review your binding financial agreement as well, so it remains strong. And that might pose some difficult questions for some people. Particularly if let's say you've got an agreement that's going to end in 10 years, and that things are already starting to feel a bit rocky around about 7. Then people are going to be faced with some fairly tough questions around that time.
Gosh, sounds like it too. Sounds like it. Again, that's something that I've learned today that I didn't know, is that they get refreshed. I thought that was the kind of thing that you did before you got married. You chucked it away in the drawer and you never went near it again.
Well, we would hope that was the case. We would hope that you put it in the drawer and it never sees the light of day again. You all live happily ever after. But look at it. You don't have to have a sunset clause in there. It's just something that is recommended by the lawyers that we use, and they're family law experts. They've done this for a long time.
Okay, well, look, we're just about at halftime here on Dollars and Making Sense, a weekly show about finance, money, and investing. I'm your host, Ray Trevisan. With me at the microphone is Ian McLeod. He is from Financial Agreements. That's right, financialagreements.com.au, RP Emery Legal Kits. We're going to take a short break and we'll be back with you in just a moment. Hi, and thank you for listening to Dollars and Making Sense, a weekly radio program about finance, money, and investing on Radio Northern Beaches and nationally on the Community Radio Network around Australia. The views, comments, and opinions aired during our program should not be construed or viewed as financial advice. Any commentary is general advice only and does not take into account your objectives, financial situation, or needs. You should consider whether the advice is suitable for you and your personal circumstances. If in doubt, you should contact an authorised licensed financial planner. We welcome questions and feedback, and you can get in touch with us via our blog, social media channels, or email. Please search for Dollars and Making Sense in your favourite podcast platform, or check out our blog at otgcapital.com.au/blog. Hi, and welcome back to Dollars and Making Sense, a weekly show about finance, money, and investing. I'm your host, Ray Trevisan. I'm really pleased to have at the microphone this week Ian McLeod. He is with financialagreements.com.au, or RP Emery Legal Kits. Now, Ian, this is a website that provides, stock standard documentation for binding financial agreements. And today we are talking about prenups, or the kind of agreement that you would sign before you get married or you're in a de facto relationship. Now, before we went to the break, we were talking about sunset clauses, which again was something I didn't realize, but you were recommending that that they build these sunset clauses into it. It's the one of those things that I'm really curious, and given your long time experience in this space, have you ever faced a situation where a couple has come to you bright, bushy-tailed and going, hey, we're getting married, but we thought it'd be good to do one of these binding financial agreements, and as a result of that discussion, they don't get married? Has that ever happened to you?
Not to my recollection. generally speaking, really, if somebody with a binding financial agreement, it's incredibly important, particularly prenuptial agreements. It's incredibly important that there be no signs of duress or coercion, like I mentioned before. And quite often, the financial agreement or the prenup is the last thing that people think of, right? So can you imagine, just put yourself in the position of a couple who are getting married, right? He's got a bit, maybe he's got a lot more than she has, whatever the case may be. But they're planning the big day. The caterers have already been ordered. They've put down the deposit for the venue. There's rallies coming from all over the countryside, and it's going to be a hell of a shindig. And a month before the wedding, he hands her a document, says, "Here, we've got to go and get this thing signed, the prenup signed before the wedding." What? how would you think that feels?
Well,
right?
hopefully, for those of you on radio, you can't see my shocked facial expression, but for those of you on YouTube and you're watching the video going, well, I'd be a bit cranky, quite frankly, if that came out of the blue a month beforehand.
Yeah. And because, essentially what you have there is a situation where one party is putting the other party in a position where they have very little choice about whether they enter into that agreement.
Was the word I was using.
It's very close to it, all right? And so you then have a situation where it might be inferred that, if we don't do this agreement, the wedding's off, right? And so what that does is that weakens the whole foundation of your binding financial agreement or your prenup, all right? And if the crunch day ever came after the wedding, that there was a breakdown in the relationship, and the parties ran off to their respective lawyers, one party will be seeking to have that agreement upheld, the other party will be seeking to have it set aside, and the party who's seeking to have it set aside, their lawyer will hone in on that conversation early, just before the wedding, and they'll say, my client was under duress, your client was acting unconscionably, taking advantage of my client.
It's commonly called, Ian, an ambush.
yeah And in those cases, that agreement would most likely be set aside by the court. So it's incredibly important that when you put these in place, that you're looking to the day that you want to rely upon it. And if somebody comes to us and it's they've got a couple of months before the wedding, it's quite likely that we would say, maybe you want to consider doing this agreement just after the wedding. So you do, rather than do it as a prenuptial agreement, you do it just after the wedding as a postnuptial agreement. And then you eliminate any arguments of, we had to do this before the wedding, it couldn't, otherwise the wedding wasn't going to go ahead, and so forth. And so by putting in place an agreement just after the wedding, right, it demonstrates that, the parties more likely have genuine agreement.
And again, before we went to the break, we were talking about the vast majority of people that you're dealing with on a day-by-day basis that are doing prenuptials are people that have already been through the mill once or twice or however many times, but they've been through the mill, and so they've got goods and chattels and potentially long family histories, particularly people with rural properties, that are farms or established businesses that have been in the family line for a long, long time. And I guess the expectation that a marriage could have any kind of impact on that ownership, I'm thinking out loud right now, but it's not a reasonable place, I think, for any new spouse to potentially venture down. But I guess when they're young and they don't have a lot at stake, the idea that you'd even need a binding financial agreement or a prenuptial probably doesn't enter into it. I mean,
Most people don't.
No, I know when my wife and I first got married, the idea of doing a prenuptial would have been a funny thing because, you know, my wife had a credit card bill and I had a mortgage. And so, you know, we looked at each other and went, well, we got bugger all anyway. So it doesn't, you know, we're going to split 3/5 of, you know, sweet FA. And so we're all okay. And I guess, you know, we sit and laugh about it now. But I guess I keep thinking about, you know, scenarios where, for example, and these are real life. You know, we're watching a battle that is, you know, life imitating art, where you've got the Murdoch family, you know, embroiled in a family dispute, and I'm pretty certain that all of those Murdochs would have binding financial agreements with their spouses that would never allow them to get their clause anywhere near the share registry of News Corp and many other family businesses along the same lines, the Waltons and the Walmarts, et cetera, et cetera. So again, I'm curious, do you see that come a lot across your desk as well?
Well, high net worth people?
Yeah.
Yeah, certainly we do. You know, particularly where you have couples where you have what we call an inequality in bargaining power. So you have one party who is extremely well off, and
You
the other
should be a
party
politician, Ian. You should
who
be a
simply
politician.
isn't.
I love those words, man. I love those words. That's glistening. That is glistening with ooze. That's glistening with ooze. What was it again? A startling inequality?
An inequality in bargaining power.
Ah, there we go. An inequality in bargaining power. Man, I'm so much richer than you.
Yeah, well, you know, like you take a typical example that we often see. You know, you've got a chap who's, you know, he's got a house and he's got, you know, a good super, and he's might have some investment properties, but he can't seem to keep a relationship together, and so he's found a wife overseas and he brings her into the country and she's got nothing. You know, she's got nothing but the clothes on her back, and he's got millions of dollars, right? So in a situation like that, to have an outcome where, right, here I get to keep all my stuff and you get to keep all your stuff, is totally abhorrent. All right, there's got to be some recognition of the situation the other party, the weaker party, may be in the event if there's a breakdown in that relationship. And as you were talking about with these the Murdochs and so forth, they will build into their prenuptial agreements some recognition for the other party in the event if there was a breakdown of the relationship. They'll give away something instead of, you know, digging their heels in and saying, I'm going to keep everything that I've got.
To live in a lifestyle that I've become accustomed to, I think, is the terminology that I've heard before. But look, so look, to round out, we've got a little bit of time left, but what I'd like to do is quickly cover off what kind of process, so that they'll hit your website, they'll make an inquiry. Do they do something similar to what we were talking about in the last show around, you know, they're separating, or is there a different process with a prenuptial type of an arrangement?
Yeah, with a prenuptial type arrangement or a de facto arrangement, binding financial agreement, the arrangement is always the same. You must receive legal advice before you sign that agreement.
Okay.
Otherwise, it has no binding force. So a financial agreement does not bind the parties unless you receive legal advice before you sign it. So
that's a very good point to note, ladies and gentlemen. That's a very good point to note. I didn't realize that. Yeah,
you must be aware of your rights and aware of the rights that you give up. So for a couple in a marriage, coming into a marriage, this binding financial agreement is essentially going to say that this is how we're going to give up, how we're going to divide our stuff. But part of that process is you give up the right to have a court make a determination about how that property should be divided. While that agreement is in force, you cannot bring an action in the family court. So lawyers must advise you and make sure that you're aware that you're going to give up that right, and you essentially lose the protections you have under the Family Law Act at the moment. Does that make sense?
Okay, well that's something that I've learned today. I thought that people could sign these themselves without needing necessarily having a lawyer present. But
No,
what you're saying is that that's absolutely not the case. They must have
absolutely
legal
not.
advice.
Must have legal advice before they sign it. And that's the second part of what we do. So I have a relationship with lawyers who are happy to provide the legal advice in relation to a document drafted from our kit, right? So long as it comes back through me first. I have to polish those documents and make sure that the agreement reflects your wishes, that it's clear and concise, and we essentially reduce the amount of time that the lawyers have to spend on each matter, so they're not
Wonderful.
redrafting the thing over and over again.
Well, look, we're just about out of time. Ian McLeod, it's been a real pleasure having you on the show. Man, I've learnt some really interesting stuff, things that I certainly wasn't aware of. And I guess I'm probably, I don't get exposed to a lot of this because I've been married for 35 years and still pretty happy. But look,
So
ladies and gents, financialagreements.com.au. Have a look at that website. Ian McLeod's services there. Look, it's a bit of a shameless plug, but look, Ian, I thank you for coming on our show and really doing a great piece of education, both for people that are separating and for people that are just about to get hitched, whether formally or informally, around binding financial agreements. Ian McLeod, thank you very kindly for your time on Dollars and Making Sense.
Oh, thank you, Ray. So it has been a real pleasure. I thank you. Cheers.
Until next time, adios.
Adios. Bye-bye.